Hey, good morning, everybody. It's John here again, and we are definitely in the thick of it. So, starting with week 4, just finished the first milestone project. Look forward to reading through those, the discussion and analysis on the legal components of the Ituraldi case. Looking forward to it. I know I did receive a few questions this week. Please. Uh, Feel free to reach out to me, phone, text, email, whatever, and let me know if you have any questions about this. I want to make sure that you're getting value out of our discussion and these assignments. So this week, I want to talk a little bit about medical records and sort of relate that to the discussion question this week. This is definitely my favorite discussion question of the class, and I'll explain why here in a little bit. But related to medical records, we touched on this a little bit before, and I know many, if not all of you, are practicing clinicians, nurses, etc. And so I'm certain that you go through some level of HIPAA training at least annually. And have to sign off that you took that training. Obviously, very important. And there are 3 components to HIPAA, so we can talk about that first. There's the privacy rule that really governs the privacy of your protected health information. The security rule, which governs the sort of the IT component, the technical component, not just the IT component, but all the safeguards that a provider, a covered entity, healthcare plan, et cetera, needs to have in place in order to protect your health information. So whether it's physical safeguards, administrative safeguards, technical safeguards, those need to be in place. The third component of HIPAA is the enforcement rule. So this is basically gives the Office of Civil Rights the authority to go out and audit and sanction covered entities for and business associates for violations potentially of or breaches of HIPAA and breaches of your protected health information. So this is where you see, I mean, there are multi-million-dollar fines that have been issued by the OCR for these sort of breaches or violations of the HIPAA rules. So that's important to know. And I think when I think about HIPAA, and it's sort of on my mind just because seems like a lot of clients are wanting to draft or update HIPAA policies and procedures. So generally speaking, there are the 3 common exceptions to that prohibition on use and disclosure of protected health information, and those are treatment. So a healthcare provider can obviously use and disclose your health information for treatment to you for that purpose. For payment, so they can submit claims to your insurance carrier, to whoever's paying your bills. They can use and disclose your health information for purposes of obtaining payment. And the third is for their own healthcare operations. So they can use your health information to help improve their own operations, the quality of care that they provide, data analytics for their own operations, and so that is something that they're allowed to do. It kind of ties back to the post that I put up on the announcements I think last week about Google partnering with Ascension for maintaining and using millions and millions of records, patient records, for purposes of really healthcare operations. That's really what both Ascension and Google are relying on, is this healthcare operations exception. Now, that Project Nightingale is such a huge one. I mean, there's so many millions of patients involved in that, or their data that's involved in that, that I think it makes people nervous. It makes obviously the patients nervous. It makes the OCR nervous, and that's why they're investigating and probably making sure that all of that is done, whatever they're trying to do in the name of healthcare operations, is within the confines of the privacy rule and the security rule. So outside of those three big exceptions, there are other permissive exceptions that a provider could rely on. Things like law enforcement, or there are a bunch of others, but those aren't mandatory exceptions, right? I mean, those are permissive exceptions. So you won't, if you do disclose for one of those other exceptions, you won't get in trouble, but you're not required to do that. So those are permissive. Outside of that, any other sort of purpose of any sort of use or disclosure requires patient authorization. And so I'm sure you've seen HIPAA authorization forms. They're required to have certain elements, and those elements are required by regulation. So outside of that requires patient authorization. And of course, overarching all of that is the minimum necessary rule, which requires that covered entities, providers, etc., only disclose or use the minimum amount of protected health information necessary to accomplish the permitted purpose. So that's important. Just covering some patient rights, other than your right to be required. Well, your right to give authorization to use and disclose protected health information for some other purpose. You have, as a patient, you have right to access. You have right to amend your protect health information. Right to what are some of the others? Accountability of disclosures, so you can get a year's worth of disclosures of your protected health information by a particular provider, and they're required to provide that to you within a certain amount of time. And if you request your records, as a patient requests his or her records, a provider has to provide that, but can charge a reasonable charge. This is on the front of my mind because I drafted some policies for a client the other day, and the client had taken a first stab at it and put in something like $125 an hour for obtaining a patient's medical records when they were requested it. And so we had that discussion where HIPAA actually does not say you can only charge whatever, $3 or $5, $6 or whatever it is. It says it has to be a reasonable cost-based charge. And so some states are even more restrictive than that, but a lot of states essentially mirror that requirement by HIPAA that says you can charge a patient for your time and for the paper, or the flash drive, or whatever it is, whatever medium you provide the medical records in. But it has to be a reasonable charge. It has to be cost-based. You have to reasonably calculate it to actually account for the costs you're incurring for providing those medical records. You can't make money off of it, so you're just accounting for your costs. So that's essentially the HIPAA side. So if you look at, medical records are actually largely not governed by HIPAA, but largely governed by state rules and regulations. But HIPAA preempts state laws to the unless the state laws are more stringent. So if the state law is more restrictive with respect to your health information, then the state law will rule the day. But if not, then HIPAA will preempt and be the governing law. Outside of that, record retention rules, notification to patients if you sell the records, or if you retain the records somewhere else, or whatever it may be. That's all governed by state law. So each state may have a different number of years in which you're required as a provider to maintain health records. So that varies state by state. And then there are other rules and laws that govern medical records. There's Medicare rules, there are Medicaid rules, there are state health department rules. and so on and so on. There are just a bunch of different rules, both state and the federal level, that govern medical records. So that's essentially what I want to talk about with respect to medical records. I did want to talk about the discussion question this week as we go into week 4. The discussion question presents it's a HIPAA question. It's a privacy question, and it presents 2 different scenarios that you're required to analyze and determine whether or not there was a breach for each scenario. So the first one I've got here. Essentially, there's a physical therapist accidentally accesses the wrong patient's record. Therapist realizes the mistake. There are a lot more facts to this. I'm just sort of giving high level here. Therapist realizes a mistake, but not before spotting that the woman suffers from a serious mental health disorder, and then discusses that with her supervisor. So there are 2 different scenarios, and you're being asked whether or not there was a breach, why or why not. So here's the reason why this is my favorite discussion question of the class, because it essentially forces you to use that form of legal analysis that we've been discussing. So you know the issue. The issue is whether or not there was a breach. So I'm thinking about the IRAC method. You know the issue. It's given to you. So what is the rule here? So in order to understand what the rule is, you have to understand what the question is. The question is, was there a breach? Well, then the next question is naturally, what is a breach? And what you'll find in the HIPAA privacy rule is that breach is a defined term. And I'm going to post it. I'm going to post the reference. I'm going to post the link where you can go actually see what breach means. So breach does not just mean improper use or disclosure of protected health information. It doesn't mean that. There's a lot more to that definition. And my light just turned off. I don't know if hold on one second. Sorry. Sorry, I think that's the second time that's happened to me in this class. I apologize. I guess I got to move around a little bit more. So breach, don't go with your gut feeling of whether or not it's a breach, because that's not legal analysis. Legal analysis is actually seeing what the rule is and applying that rule. So the rule here is based on the definition of a breach. You'll see that the definition of a breach includes some different factors to consider. It's an actual analysis itself within the definition. Some factors to consider, some exceptions are part of the definition of a breach, and so you're going to need to read the rule, understand the factors, apply those factors, understand the exceptions, apply those exceptions to the extent they're applicable based on the facts, and come out with your conclusion. So I kind of get a varying level of responses in the discussion questions based on this, and because I think some students don't really focus on that rule and say, okay, well, based on this factor, this factor, this factor, this exception, which are, those are part of the definition of a breach. You have a breach here, you don't have one here, or vice versa, whatever the case may be. And then I get some that just don't even think about the rule and just kind of go with their gut. So I'm asking you to really kind of get in that mode, get in that habit of thinking critically about these sort of fact scenarios, and utilizing that the skill. It's really a skill of legal analysis. I'm going to give you the rule. I'm going to ask you to apply that rule. Again, I'm not grading on your conclusion. I am not looking for a right answer here. I think the right answer will come if you go through this method of legal analysis, and if you're reasonably applying the facts to the rule, I think you'll come out with the right conclusion. But I'm not looking for the right conclusion. I'm looking for just this process of legal analysis. So issue the rule, which in this case will be the definition of a breach, applying the rule facts to the rule and coming up with your conclusion. So anyways, that'll be important this week. I'm looking forward to I think there's always interesting discussion posts because of that. So I will post all that in my notes. And there'll probably be 2 different posts today for me. Just this one here with the link to this video, and I'll post a second one so it's clear and distinct that has the link to where you can go see what the rule is for a breach under the HIPAA privacy rule. So that's all I have. Have a great week. Again, if you need anything, please feel free to reach out. Thanks. Have a great one.